Hello, Pranam, Adab, Sat Sri Akal, Sariyanu. मैं ਤੁਹਾਡੀ साक्षी Kilawat back again with PT 365. We were discussing issues related to the Constitution. In this video, we'll learn about sedition, which comes under Section 124A of the Indian Penal Code. Before seeing into the definition of sedition, let's learn about its history there. That is, before independence, in 1870s, the section on sedition is introduced by the British to the IPC. The British rulers used the law to muzzle demands for freedom. And the first one to be convicted of sedition in colonial India was Bal Gangadhar Tilak. ये fact important है, इसे note down कर लो. That is, the first one to be convicted under sedition was Lokmanya Bal Gangadhar Tilak. After independence in 1948, Indian leaders in a discussion agreed to drop sedition from the constitution. 1949 में sedition is no longer part of the Indian constitution adopted on November 26. However, Section 124A remains in the IPC. In 1951, Nehru government brings in First Amendment under Article 19, Clause 1, Subclause A, and puts in reasonable restrictions on the right to free speech. In 1974, Indira Gandhi government makes Section 124A a cognizable offense. Cognizable offense में it authorizes police to make arrest without a warrant. Police can arrest a person without a warrant. अभी देखते हैं इसका definition. Section 124A of the IPC, which defines sedition as an offense committed when any person brings or attempts to bring into hatred or contempt, excites or attempts to excite disaffection towards the government established by law in India by words, signs, visible representation or otherwise. वर्ड साइंस या किसी विजिबल रिप्रेजेंटेशन या फिर कुछ और तरीके से अगर कोई पर्सन गवर्नमेंट के अगेंस्ट हेट्रेड, कंटेम्प्ट या डिसअफेक्शन फैलाना चाहता है तो उसे सेडिशन के अंडर पनिश किया जा सकता है. सेडिशन इज अ नॉन बेलेबल ऑफेंस. नॉन बेलेबल ऑफेंस यानी person who has been accused of it cannot remain free on bail until the trial. इसी के opposite अगर the criminal offense is bailable तो person can remain free जब तक trial नहीं होता. It provides for punishment of imprisonment for life or imprisonment up to 3 years with fine. इसका पनिशमेंट या तो इम्प्रिजनमेंट फॉर लाइफ होगा या फिर इम्प्रिजनमेंट अप टू 3 years along with fine. There are various verdicts in sedition. The first one, that is Romesh Thapar case of 1950. In this case, the court, while ruling on the validity of imposed order that banned the entry and circulation of the weekly magazine into certain parts of Madras, held that the freedom of speech and expression includes freedom of propagation of ideas that can only be ensured by circulation. फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन में फ्रीडम ऑफ प्रोपोगेशन भी इंक्लूड होता है. और प्रोपोगेशन कैसे होगा? बाय सर्कुलेशन. द नेक्स्ट केस इज केदारनाथ सिंह 1962. In this landmark judgment, the Supreme Court upheld the constitutional validity of the sedition law. It attempted to restrict its scope for misuse. The court held that unless accompanied by an incitement or call for violence, criticism of the government cannot be labeled sedition. Mere a criticism of government cannot be taken as sedition until and unless it incite or call for the violence. There are some other cases like Pallavi versus State of Kerala. It was in 1982. In this case, the court held that sloganeering, criticizing of parliament or the judicial setup did not amount to sedition. स्लोगन देना या पार्लियामेंट या जुडिशियल सेटअप के अगेंस्ट क्रिटिसाइज करना सेडिशन नहीं कहलाता. 1995 में बलवंत सिंह एंड एएनआर वर्सेस स्टेट ऑफ पंजाब, इसमें कोर्ट ने रूलिंग दी थी दैट रेजिंग सम स्लोगन, इसमें खालिस्तान जिंदाबाद वाला स्लोगन था, रेजिंग सम स्लोगन अ कपल ऑफ टाइम्स व्हिच नाइदर evoked any response nor any reaction from the public cannot attract such punishment. अगर इन्होंने इसमें जो स्लोगनियरिंग की थी, इसमें कोई रिएक्शन नहीं आया पब्लिक से और कोई रिस्पॉन्स भी नहीं आया, तो उसे इट कैन नॉट अट्रैक्ट सच पनिशमेंट. रिसेंटली कन्हैया कुमार केस ऑफ 2017, जो JNU वाला केस था, who supported Afzal Guru's the convicted Afzal Guru via poetries and some events. In all these cases, sedition was redefined as act only if it had essential ingredients as disruption of public order, attempt to violently overthrow a lawful government, threatening the security of state or of public. Sedition मतलब कोई एक्ट सेडिशियस तभी होगा only if disruption of public order या फिर lawful government को violently overthrow करने का attempt हो, या फिर स्टेट या पब्लिक की सिक्योरिटी थ्रेटन कर रहा हो, तभी उसे सेडिशियस एक्ट अंडर सेडिशन कहलाएगा. इसका डेटा देखते हैं. 2019 डेटा which shows that sedition cases rose by 25% and arrest by 41% over the previous year. पहले के हिसाब से, पहले ईयर के हिसाब से, that is 2018, सेडिशन केसेस में 25% बढ़ोतरी हुई है और उसके अरेस्ट में 41%, जबकि ओनली 3% केसेस लीड टू कन्विक्शन. That's all for now. Bye bye. Have a good day. Stay safe, guys. Stay healthy.